Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Could we please bring up the second witness statement at page 13, paragraph 26? You're discussing governance arrangements at this point of your statement. And at paragraph 26, you say, I think the hard part tended to be actually getting Post Office to do what ministers wanted. As described above, the department did, from 2020, have a power to issue directions to Post Office, but ministers could not routinely become involved in the nuts and bolts of operational decision-making. And at paragraph 27, you give an example of this in managing legal costs, which we'll come back to. But if we could go over the page to the bottom of paragraph 27. You say, for these kinds of important but ultimately operational matters, if Post Office did not do as we asked, we had relatively few levers with teeth other than the ones that had other issues, brackets, like removing the chair or pushing the organisation into financial trouble. Did you experience similar problems with other ALBs, namely finding it hard to get the ALB to do what the minister wanted whilst you were permanent secretary?
I'm just sort of testing my mind for examples. Yes, I think is the right answer to that. It varies according to the structure of the arm's length bodies, and an example like Post Office is sort of quite arm's length. So there'll be other examples like executive agencies where you might have much more explicit clearances over salaries within the organisation, for example. But the idea that like in many situations where you're in a supervisory or a management function over somebody or another organisation, although you may have a sort of set of formal levers at your disposal, often sort of your first port of call is influencing. It's a bit like if you're managing an employee. You might ultimately have the ability to terminate them, but that's a really drastic step and one that you wouldn't take until you've gone through talking to them about why you want them to do what you want them to do, hearing what they think about it, trying to give them some training, increase their capability. I think it's a very common journey, and I certainly saw it with other arm's length bodies as well. I do think it's particularly acute in this case because the combination of being at the more extreme end, like a long arm, if that makes sense, in the context of the Post Office, combined with being so troubled and having rightly so much political attention on it, I think that's a really difficult combination. Whereas if you took a body, if I compared it to something like the Ordnance Survey, just to take an example, you'd have a similar set of levers and a similar degree of arm's lengthness, but just a much lower level of heat, at least during this period, around the organisation and its performance. So I think that's why it sort of comes quite acutely in the case of Post Office, because you're combining a long arm with a very great deal of legitimate political interest.
Reflecting on matters, have you thought, or can you assist us with whether there are any other levers that would assist in managing Post Office in this way?
It's a good question. It's maybe worth just reflecting for a minute on, you might say if we had the ability to make directions, why isn't that sufficient? I mean, that's actually quite a strong lever, right? That's effectively creating a capability for the Secretary of State to say, Post Office, you must do X. And I think the reason that has tended not to be that relevant is there aren't that many decisions in a complex organisation like the Post Office that are sort of really like simple and binary. Should I X or should I Y? It's often much more complex. So if it comes to something isolated and specific, a sort of direction power where you can say you must X works well. And I think that direction power came about in response to the events that surrounded earlier handling of the litigation, where there were some quite specific questions, including the one about recusal of a judge. I'm not over all of the detail, but those sorts of matters, it kind of, you can imagine a department being able to say to an arm's length body, you must X, therefore X. But something like reduce your legal costs, which is the example I use in my witness statement, it's much more of a sort of debatable point, because the Post Office, not illegitimately, would want to come back and say, well, we need these legal costs for reasons X, Y, Z. We are going to reduce them, but not until next year, because the contract needs to come up for renewal, et cetera, et cetera, et cetera. So it's much more of a dialogue about what is and isn't reasonable, rather than a sort of, you can order people to do things. That tends to be oversimplistic for what we're talking about here, which is why actually the influence, the presence on the board matters, being part of the discussion, understanding the nuance and the detail. So I think I find it quite hard to answer your question with a really specific, like, if only we had power X, we would be able to make everything okay. I don't think it's like that. I think it's more like having a strong, productive relationship with respect on both sides, and listening to each other has got to be the right starting point. And I don't think the formal arrangements that we had during this period precluded that.
I want to look at one example, please. Could we look... well, we don't need to bring it up, actually. You refer to the review of Tim Parker's decision not to share the SWIFT report. That's, for the record, paragraph 18 of your statement. You describe it as a governance failure. And you say, after learning of this and giving consideration to whether we should advise ministers to fire Mr. Parker, formal censure was chosen as the appropriate course of action. Was a minister involved in the decision to censure Mr. Parker rather than terminate his contract?
Yes. That decision would ultimately have gone to, I know for sure it went to Paul Scully, the minister. I don't recall specifically whether it went to Secretary of State. It may not have. It may have been a delegated decision, but that was signed off by ministers. But as I do say, just for the sake of clarity, I do say in my statement that was on our advice, and our advice was formal censure. So you might, I wouldn't wish to sort of put it only on ministers, but yes, of course, any decision like that would be signed off by ministers.
Could we look, please, at poll 204104-180? This is your letter to Tim Parker after that decision was made on the 7th of October 2020. The second paragraph, please. Thank you. You refer to the background to that, which is well known. And towards the end, you say, we consider it was a mistake not to have ensured that the whole board had an opportunity to see and discuss the detail of its findings and agree what any next step should be. With hindsight, this information should have been seen by the board, and we are disappointed that it wasn't. And you go on to say matters about sharing documents said to be legally privileged. Firstly, why did you say with hindsight this information should have been seen by the board?
I think it's sort of felicitous drafting. I'm not sure there's any deep significance to with hindsight. I mean, had we been asked the question at the time, in possession of the full data, one would have said the same thing at the time. If you or I was transported back to the moment where that decision was made with the report in front of us, I hope we would have decided that it should have gone to the board.
It might be said that this letter doesn't contain a sufficient degree of criticism or disapproval to be described as a formal censure. What would you say to that?
it's certainly one of the harshest letters, if not the harshest letter, I have ever written to a chair of an arm's length body I've been involved with, and I've been involved with a very great many arm's length bodies over some considerable period. So, opinion could differ, but I would say that as a matter of fact. It's fair to say that, I think as I say in my witness statement, as I reflect on it now, I actually think the advice probably should have been to
we'll come to that
go further.
In a moment.
So I agree, in other words, that sort of looking at it now, you wonder why we didn't go further, and that could include either a sort of a harsher drafting or indeed a different decision altogether.
Was Mr. Parker told that dismissal had been considered as an option?
I couldn't say for sure.
I can come down, thank you. You just said there about what you say in your statement regarding whether that was the right decision. We don't need to bring it up, sir, but for your reference, it's paragraph 18, page 10 of the second statement. You say, with the benefit of hindsight, it was perhaps the wrong decision not to take the harsher course of action and terminate Mr. Parker's appointment. So again, you say with the benefit of hindsight. Have you learned anything since October 2020 that now makes you doubt the decision that was made? Well,
yes.
What would you
I mean, I think probably lots of things fall into that category. So, first of all, I think all of us, at least on the HMG and post office management side, over time, the full depth of the scandal in the first place has been sort of further elucidated. So I'm not saying it, obviously at the time that this decision was made, we knew this had been a very serious error, but as the sort of the picture grows around it and you try to isolate, what were the moments that could have made a difference? I think now I would see that moment where the Swift report wasn't shared as a relatively critical one in the story. At the time, I don't think that was as clear to me, simply because, I mean, I've obviously been following the inquiry closely and all of the events that have happened in HMG as well. That just wasn't as clear to me at that time. I don't think there's sort of one particular fact I've learned, but as just the picture becomes deeper and clearer, that looks like a critical moment. And I also think at the time, it was an in the balance decision that was considered both ways, if you see what I mean. And at the time, the advice of the SID was taken into account, and it was also kind of top of.
When you say SID, do you mean Chemical?
Yes, I'm sorry, the Senior Independent Director Chemical. Thank you. It was also kind of the decision in the round was taken in recognition of the fact that switching people out causes instability, and that there would have been all sorts of challenges with trying to get another chair at that time. And I guess that felt like a very important issue in the moment. And now when you look back at the picture overall, on lots of cases here, I think you ask, should people have been bolder in making changes? And this, I think, therefore, I probably see it with that perspective now.
At the time, Ms. Munby, were there senior people who were consulted about the issue, who actually favoured terminating the chair? Or was it more or less a unanimous view that censure was appropriate?
I don't remember anybody sort of specifically pushing, but it was certainly a decision on which many of us, myself included, felt was very much in the balance, if that makes sense. I don't think there was sort of there wasn't like a censure side and a termination side and we were having a face-off. It was more like a debated issue that we were discussing as a senior team what we thought was best, and this was where we landed.
Okay, thanks.
At the time, were you involved in any oversight of or investigation of whether officials within the department had knowledge of the Swift review?
No, or not that I remember.
do you think such an investigation should have been carried out?
Possibly. I don't remember enough of the facts surrounding the case to give you a really confident answer on that, if I'm honest.
I want to turn now to look at some of the compensation schemes. I'm going to deal with this at a relatively high level because we've heard evidence from Simon Ricaldin and Carl Creswell, but will be giving evidence on the issue later this week. In your statement, is it fair to say a common theme that you point to as the reason for the alleged or the delays in compensation is what you describe as an underestimation initially of the scale and depth of the challenge in providing redress to postmasters?
Yes.
I want to begin by looking at the effect of managing public money on compensation schemes, please. Could we bring up poll 20413-475? So this is Managing Public Money, the May 2021 edition, and would you agree a fair summary of this is that it sets out the main principles for dealing with financial resources in the public sector?
Yes.
And during your time as Permanent Secretary, the Chief Executive of Post Office was an accounting officer for Post Office.
Yes, it's a little bit more complicated than that because you have a structure where you have a principal accounting officer at the departmental level, and then depending on the nature of the status of an arm's length body, the CEO may be an accounting officer in their own right. I think it might be the case in Pol specifically that they're more correctly described as an accountable officer, but which is I think a technicality, but it is of course fair to say that what's in here would represent principles that the CEO of the Post Office should have in mind.
And as Permanent Secretary and Principal Accounting Officer for the department, your responsibility was to make sure there were arrangements in place to satisfy yourself that Post Office had systems adequate to meet the standards required of managing public money.
Yes, insofar as they applied to any particular aspect of the Post Office's operations,
yes.
Because obviously much of the money that Post Office was dealing with wasn't quite correctly described as public money.
Could we look, please, at page 20? Paragraph 3.3 says there are several other areas where accounting officers should take personal responsibility. And at points 1 and 3, we see regularity and propriety and value for money. And in your in the documents that we'll go to, it's fair, isn't it, that regularity and propriety and value for money are concepts that were applied to the establishment of the various compensation schemes.
If I may, there are 4 core concepts that underpin any accounting officer test, as I would put, on any new announcement that the department was making. Those are regularity, propriety, value for money, and feasibility. And any major new initiative by the department needs to be assessed against each of those 4 criteria and needs to have personal sign-off from the accounting officer before it can be launched.
So I think, subject to you adding feasibility, the answer to my question was yes.
Yes, I mean, I guess I'm saying yes, very, very much so.
If we turn, please, to page 15. In box 2.4, just slightly down, we have a description of regularity. It says regularity, complying with the relevant legislation and wider legal principles such as subsidy control and procurement law, delegated authorities, and following the guidance in this document. When we're considering compensation schemes, does regularity apply in the sense that the question is whether or not there's legal authority to make compensation payments themselves, or does it also apply to whether any compensation payment that is made must itself be justifiable in legal terms?
I don't think it follows from the principles of regularity that you can only compensate people to the extent of your legal obligation. And indeed, I'm sure you know that, within the sort of framework for initially the HSS, the sort of core documents of the scheme were about trying to offer fair compensation, even insofar as that went above what was sort of a strictly legal obligation. And I have certainly never understood regularity to mean that. Where regularity has been very relevant in the context of the post office, where this test has been particularly live, is actually where you're talking about payments from the department to the post office, and then from the post office to members of the GLO class, where the question of under what parliamentary authority were we making those payments, this is probably well known to the inquiry, was very, very kind of extensively explored. That would be a regularity issue. Is the expenditure regular? Is it properly sort of sponsored by Parliament? I have never made any comment, I don't think, on regularity in the context of individual compensation payments. And the reason for that is ultimately the accounting officer requirements come second to the question of whether the policy intent of the minister is being fulfilled. So, you're asking the question, the compensation needs to be full and fair, and then we need to find a way of making it regular. You don't say, I'm going to use regularity as a way of not making it full and fair. And so if ministers think that fair goes beyond legal liability, and ultimately that's the sort of question that is for ministers, then the only regularity question is whether we have a piece of parliamentary authority that we can use to make those payments. You would never use regularity to sort of undermine that ministerial perspective.
Just out of that point, how does the value for money aspect of managing public money fit in the context of compensation schemes? So
basically the same point. It's worth mentioning there's, at least in the latest edition of Managing Public Money, there's quite explicit reference to compensation schemes, in which in effect it says the same processes apply in compensation schemes. They're like any other form of public money expenditure, and value for money, regularity, etc., apply. Again, value for money is always about value for money for a given ministerial objective. So it's not like you have to justify, is it value for money to deliver full and fair compensation? The requirement is to deliver full and fair compensation. The question that an accounting officer would be asking themselves, and I did ask myself, is, are we delivering that full and fair compensation in a value for money way? And there's probably a few aspects that come up there. Firstly, and very obviously, are the procedural arrangements for running the scheme good value for money? And normally you would want those costs to be as low as possible, although clearly that's not an absolute rule because, being slow also adds cost. The second thing you would usually have top of mind when you're thinking about a scheme like this is the area of fraud and error. That's been a really substantial problem in a lot of government schemes. In this case, I want to be clear, I'm not suggesting that there was any fraud in any claims made, but you would, for example, want to be confident that you weren't making payments to people who weren't postmasters, would be a good example. An error is another very common characteristic. That would be particularly things like where you make the same payment twice. So you don't have sufficiently good record keeping and you pay out a grant and then you make the same grant again to the same person without realising. That would be an example of error. And again, that would be, regardless of what sort of scheme you were looking at, that would be top of your mind as an accounting officer. I think with compensation schemes, it gets more complicated when you get to what level of compensation is value for money. And ultimately, the first place you look there is for what was the original policy intent. And in this case, that was for the compensation to be full and fair.
But is it fair to say that the value for money is relevant to the question of the amount of compensation that is paid? Namely, is there when considering value for money, does one have to consider whether compensation payments made are too generous or overly generous?
It would really depend on what the ministerial steer was. So let me give you an example. In this context, at the kind of early stages of HSS, and indeed for some time, this was not just a short-term thing, the sort of principle on which the payments were being made was that there should be fair compensation at an individual level, i.e. the amount of compensation that an individual received should relate directly to the injury and suffering that they had experienced as an individual. Once that's your policy intent, then yes, value for money principles would suggest that you should compensate people to that point and not further, except insofar as that was a sort of reasonable compromise in the grand scheme of things. Whereas, later, I know that the schemes have moved to much more sort of fixed offers that move away from the principle of sort of compensating according to individual level of loss. Once you've made that decision that that's your intent, then you would look at value for money from a different angle. So I guess you can't sort of discuss value for money in the abstract without understanding the goal that you're trying to achieve. But once you have specified that goal, and once you have specified a principle like you're compensating on a kind of an individual basis, then yes, of course, you would expect value for money to be relevant, just as it is, I should say, in absolutely every other aspect of any government money spent anywhere.
Can we look, please, at UKGI 30188879? And if you could go to page 2, please. We see this is an email from you on the 30th of June 2020, and it says the subject is for comment close, Post Office convicted postmaster's compensation scheme. And you said, one point of clarification from me: does the establishment of the compensation scheme prevent the malicious prosecution claims, i.e. can it actually close off the risk of larger sums materialising in any case? Is it that we expect claimants to prefer a cheaper / less risky route, even if for a lower benefit? If so, how sure are we that will be true? What was the purpose of your questions at that point? Why did you seek those answers?
I hope this won't seem like a cheap answer. I mean, because I was seeking to understand. So this is very early on in my engagement with this scheme. I've just been given a piece of advice. I actually remember, interestingly, not getting factually whether it was the case that by running a scheme you sort of close off the legal route or don't. And that seemed to me an important point. I wasn't pushing a particular point of view here. I was genuinely just seeking to clarify the situation and to understand better. It's quite a large, it's a significant piece of policy work, significant money associated, and I felt I should understand what was going on. You'll see later I get a reply and I say, sounds good, go ahead.
Well,
I didn't have an agenda.
I'm going to come to that reply now, please. Can we look at the bottom of page 1? We see an email from, sorry, I've gone a bit too far. It's an email from Tom Cooper, 1st of July 2020. It says that it won't prevent claimants from pursuing a malicious prosecution claim, but goes on to say, the point is to provide a quicker and cheaper route to redress compensation than having to go through the courts again. This is in the interest of all parties, of course, claimants, Post Office and His Majesty's Government. To your last point, we would always expect claimants to take some discount to the full potential value of a malicious prosecution claim because, one, the outcome will be inherently uncertain as in any litigation. Two, it will take a very long time, particularly if there are appeals. And three, it will involve substantial costs which some or claimants may have to fund externally and for which they will end up having to give up a large share of the proceeds if they win. Is it fair to say that at this point one of the policies behind the schemes was to seek to settle the claims at a value less than they may have been at trial?
Yes, although I would caveat that by saying I don't think the sort of overriding consideration was to settle the claims at a value less than they would have received at trial. It was that settlement is, generally, I think, lawyers might disagree, but generally a better approach for all parties. So I would just, I don't think that's to negate what you just said, but I just think it was more that context than a sort of, financial minimisation as the core motivating factor.
Could we look, please, at base 40961, please? It's an email on the 8th of September referring to a meeting the day before. We see there are attendees from Post Office, including Nick Reed and Tim Parker, and you are listed there as Perm Secretary. Could we go to page 2, please, for part of the readout? And it says, Tom noted that although Alan has taken the thinking on this quite a way, Tom is keen that BASE/UKGI don't get too involved in the detail of the schemes, but focus more on the communication side of things. Pausing there, was that an accepted position within BASE at that time, in September 2020?
I'm not sure.
Okay.
Sometime around this time, and I'm not sure I could put the chronology, was it exactly before this meeting or after this meeting? But this was during the period where we moved from sort of thinking this is mostly a Post Office thing to we really need to get across this in a very great deal of detail. And I'm just not sure I could put exactly where this fits in that chronology. Apologies.
Goes on to say, Carl asked whether PermSec, that's referring to you, had any views as accounting officer and ensuring propriety, VFM, I assume value for money, ethical considerations on any comms statement. Permanent Secretary wanted to know if the wording of the statement was consistent with only mediating on the cases that would come up. Can you help us with what that means?
I don't remember.
It says the Permanent Secretary noted that none of the schemes are terribly attractive. Why did you think none of the schemes were terribly attractive?
At that point, we were discussing a range of different options, all of which were expensive, all of which were onerous for everybody involved, government and postmasters, and it kind of being given a set of options to choose from about how we might approach compensation. There wasn't one that I looked at and thought, yeah, you know what, that's great. It was choosing between, choosing between difficult options, none of which were perfect.
I'm sorry to interrupt again, but can I be clear? At this point in time, I think we're in early July, are we, 2020?
This is September 2020, sir.
Right. So HSS has already launched. So presumably you're here talking about what to do with the people who are having their convictions quashed. Is that it?
That's right. I think there was a presentation at this meeting about various different approaches for dealing with what later became the OHC.
Yeah, fine. Thanks.
You go on to say, he says, Carl said that all options and entitled to in the statement suggest the government is committing to give more compensation to claimants than they would actually be receiving. Carl/PermSec noted that through mediation, some claimants will receive much less than they think they are entitled to. Again, can you recall precisely what your concern was here?
So I'm going more by reading the text and thinking what it probably meant rather than having an exact, precise recollection. But we were looking at a draft of a public statement, which is very normal at this stage. Like, what are you going to announce, basically? And here, this is, talking about making sure that the statement doesn't overpromise relative to what we're actually planning to do. And without having the statement draft in front of me, I'm not sure I could tell you exactly what the problem with the statement was. But what this looks to me like is a discussion where we're saying, look, the two need to match. If we're going to give this sort of like very forward-leaning statement, are we confident that what we're proposing, this mediation-driven process, are we confident that it actually delivers against it?
Could we move on slightly in the chronology, please, to UKGI 30/43126. Page 5, please. If we go down slightly, please. So we apologies, I think I've got the no, that's right. So this is from Permanent Secretary. I assume that's your private office email address.
That's right.
Yeah. Just had a conversation with Joshua. Sarah has some concerns with the AO assessment, presumably accounting officer assessment.
That's right.
And isn't happy to clear yet. If you could go down, please. It has a high value for money risk, and we're not sure why. What we need is an assessment of this announcement, which leaves room to design a value for money scheme. And it goes on to say we need a clearer answer on why we are confident this won't lead to a regularity challenge. Can you recall what was driving your concerns in respect of your accounting officer assessment of the schemes at this time?
Yes, and with all due respect to those who wrote this particular piece of advice, what this feedback is me saying this advice is not good enough. So the advice I received at that time, just to take VFM as the example, had what an accounting officer normally does is takes those 4 tests I was talking about earlier and gives like a rating against each of them. And this piece of advice had a red rating against value for money. And you can't, as accounting officer, just let that pass by. If it has a red rating for value for money or one of the other tests, you need to engage. And ultimately, if you really thought it was a red rating for value for money, if that was your considered opinion after getting the best advice you could, then you would actually need to ask for ministerial direction. Now, I absolutely did not think that was the case here. And what I was asking for is for the team to come back with basically a more intelligent piece of advice. What they had done at the time is they'd said, we haven't designed all the details of this scheme yet. It's still quite uncertain. And so it feels risky. So we're putting a red for value for money. But what I was trying to point out is all we're doing is making one step forward. We're announcing the scheme. We're not tying ourselves down to an exact set of details. There's plenty of room within that to make sure that we do design a scheme that passes the accounting officer tests. And of course, that would be our intent, and that's what we would do. So I was asking them to go back and, basically create a piece of paper that, rather than saying this is all red and bad and you can't announce it, reflect the truth, which is this is fine from an accounting officer point of view, and it's perfectly ready to be announced, which was my view.
So we take this as a criticism of a draft rather than a substantive position on the managing public money assessment.
100%.
Please, could we look at Bayes 40990? This is a briefing on the 10th of June 2021, so we're jumping ahead again in the chronology, and it's a briefing which we will come back to. You see, it's on the ownership of criminal convictions compensation, which regarding who runs that scheme. Could we please look at page 3, paragraph 12? Sorry, not paragraph 12. It's just a bit further down where it says efficiency. Thank you. So this is one of the pros, it says, of the government taking on direct ownership for compensation from Post Office. In either situation, we will need to scrutinise aspects of the compensation closely from a MPN, presumably managing public money perspective.
That's right.
This has caused Post Office some frustration in relation to the HSS scheme because of the process and conditions that we have had to mandate. Do you recall what Post Office's concerns were in relation to managing public money in relation to HSS?
I don't really remember them as being specifically about managing public money, but there had certainly been back and forth around governance and our involvement in the governance around HSS. I think by this point we had started putting pressure on around legal costs and administrative costs, which had been a very kind of tense set of discussions, and that certainly was a managing public money issue. I think if I had characterised what I knew at this point, I think I would have said more that they had sort of concerns or frustration from a governance perspective, maybe, rather than it being particularly an explicit dispute about managing public money. But clearly the drafting here suggests that. That was just been my perspective.
That document can come down, thank you. It's been suggested by some that the approach to the compensation schemes has been litigious or legalistic. Have you heard that criticism?
Yes.
Do you have sufficient knowledge of the operation of the schemes to have a view on that?
I think I do, although it's a partial one, and I'll just sort of say it as I see it. I think there's two aspects to this. And the first comes back to what I was talking about earlier, about taking a case-by-case approach to the schemes. And I mean, in my witness statement, I talked about sort of, if you went back, what might you do differently? And in a way, that original decision to have a scheme that was based on individual applications and assessments of individual applications, even if for a moment you put aside any concerns about how you do that, I'll come to those in a second, but just putting those aside, just inherently asking people who have been through something truly awful to go back over it as part of an application process has challenges, even if you do it in the absolute best possible way. So I think that's sort of point one. Point two then is actually particularly through the process here, I think there have been cases, but frankly, the inquiry would be as well placed to comment as I am. There have been places where you look back and you think, an individual case was handled not as generously as would be sort of properly viewed as compatible with full and fair. I don't think, certainly from my perspective, I never saw ministers or officials seek to achieve that outcome. And I didn't at the time see any evidence that the Post Office at a sort of corporate level was seeking to achieve that outcome. I think others are probably better placed to sort of say what happened on the ground and how it felt. But maybe a reflection would be that, you know, once you pass intent through a system, at the end, you might not always sort of feel the intent you started with, especially once you've gone down the, you know, perhaps necessary at the time, road of assessing each case individually. Because if you assess cases individually, it takes you down a path of wanting to see some level of evidence. And you can get into, and you may well wish to, discussions about like what the evidential bar is. But the difficulty with a system that assesses individual cases and has no bar whatsoever for evidence, if you have no requirement, is then it is 100% a matter of whatever is asked for, you will pay out without any process at all. And that is difficult from a managing public money point of view, because, of course, everybody would always like to receive more money. And if you don't ask for any evidence at all, it's really hard to know, are we compensating fairly, or are we starting to get to the point of, I don't mean sort of minor overcompensation, but, you know, really serious overcompensation based on claims that aren't right. And that I think that's a really difficult trade-off. And I do sort of wonder, looking back, you know, how easy really is it to design a scheme that looks case by case, but that doesn't end up feeling litigious to at least some of the participants in that scheme?
If we look at your statement, I think you deal with some of those issues. It's your second statement, please, page 25. Page 25, yeah, it's paragraph 51. You refer to other approaches and the sort of application-based approach as it would necessarily have been much more blanket in its nature, and probably would have meant we all had to accept paying people whose circumstances were different the same amount as each other. Likely the only way it would be proved acceptable to postmasters is if the numbers had been numbers had in general been much higher overall, levelling up. For His Majesty's government to have gone down this road, officials and ministers would have had to give up on two quite fundamental principles. First, fairness both as to between different applicants and as to between sub-postmasters and other victims of past injustices. And second, standard use of public money, as you would have had to accept making payments that could not, by any normal standard of judgment, be viewed as compatible with the formal guidance for spending taxpayer money or managing public money. Do we take from your evidence at the time of, so putting ourselves back to September 2020 thereafter, that there wasn't a discussion on these more blanket approaches, which we've seen in post-2024?
I think I remember we were talking about that meeting earlier where there was you had the readout from it and you were asking me what things meant. As I remember, there were options in there that went to tranche-driven approaches, i.e. where you define a series of classes and then have kind of flat payments within class. I don't specifically recall, but it could have been. I don't specifically recall a proposal which was around kind of a single, very generous class, which is in effect what I'm describing here.
And so there wasn't the proposal you're describing here wasn't put forward to a
It's
minister?
not, yes, I think it's important to say it's not that lots of people were saying that this was what we should do, and I or somebody else came out and said, no, that isn't compatible with managing public money. I think it was almost perhaps taken as read that we would have a scheme that, broadly speaking, sought to provide as close as possible to full and fair to individuals. And you might have gone as far as a tranche-based approach, which obviously is not quite as precisely gradated as an individual approach, but is still gradated. I certainly don't remember an extensive debate. It may have come up once, I couldn't swear to that, but it certainly wasn't sort of extensively debated. And I certainly never said, you can't do that because of value for money reasons, because the question was never put to me in that way.
Looking back at that time, do you think sufficient consideration was paid to all the available options?
I mean, in one sense, the answer to that has to be no, because we're much further down the path, and you look at where the schemes are now, and knowing that that is where you're going to land, it is just undoubtedly, irrefutably true that if that's where you're going to land, you would have been much better doing it earlier for everybody's sake, and particularly for postmasters. So in that sense, it was definitively wrong. However, if you go back and look at the environment that we were operating in at the time, being absolutely frank, I think if the proposals as they are now had been put on the table at that moment in their current form, but sort of put back into the historical context, I think we would have had insurmountable difficulties with HMT, the Treasury, with ministers, actually, and possibly, although it's always hard to answer this, possibly with me as an accounting officer. I think all of those sort of formal clearance moments would have been very, very difficult to get through. And so I don't think that kind of radicalism was properly contemplated at the time. And so the question I ask myself is what would have to have been true to get the system as a whole to operate in a more radical mode faster?
Well, what changed between then and now? In the sense of you've said if we know where we are now, it wouldn't have been possible back then. What do you think the key differences were between the two times?
I mean, ultimately and sort of operationally, the strength of the ministerial steer to address the problem in full, sort of, and I use these words sort of appropriately, but kind of at any cost.
And what caused that change in position?
That it wouldn't be for me to answer. It happened after my involvement, and I wasn't there.
Let's go to what you say. You talk about some of the reasons for the delay. If we could.
Before we do that, Mr. Stevens, just so I'm clear, what you mean by the now are things like having fixed offers of £600,000 for convicted people whose convictions have been quashed, or fixed payments of £75,000 for people in the HSS. That's the sort of thing that you mean in relation to the now, is it, Ms. Munby?
Yes, that's exactly right. So when I would add to that list, although it's not a VFM issue, but the other sort of kind of fundamental overturning of the initial principles would be the mass exoneration, which would be another example.
The ultimate step, if I can put it in that way.
Yeah.
But the steps to it were things like, in inverted commas, what might be considered, and I choose my words carefully, as realistic fixed payment type options for postmasters to take up if they didn't want to go through a process of individual assessment?
Yes, I think fixed payment and interim payment options were, of course, considered earlier, and indeed, at least in the case of interim payments, implemented earlier. So I think it's the combination of being fixed and also the relative scale of them. I think that it's that combination that it would have been hard. I think even if we had had an official who was pushing that agenda, I think they would have met obstacles in the system. I just want to be honest about that.
Yeah, so I don't mean this in any flip sense at all, but Mr. Ricaldin was talking about the journey that postmasters have been on. You're almost describing a journey that civil servants and politicians have been on in terms of trying to achieve full and fair compensation.
Yes, I think that's right, although, like you, I wouldn't compare the journeys in their challenge or emotional cost or anything else. But I think the thing I've reflected on is when you get to the end, you always look back and you think, well, why didn't we just do that to begin with? Because as I've said, if you know that's the destination, it's much better to get there quickly than more slowly. So the question really is, why not? What was it that meant that didn't happen? And I think there are probably a series of reasons to do with underestimating the scale of the challenge, which you mentioned, Mr. Stevens, earlier, but also a belief that the processes would go better than they actually did. A sort of an excessive, what now with hindsight is obvious was an excessively high level of faith. I don't mean in the post office's ability to run those operations, actually, because as I said in my witness statement, I think many of the challenges might have been similar even if they had been run in the department or by an independent body, but a sort of confidence that the application of sensible governance and processes would lead to the correct outcomes. And actually what we saw is that application of what looked, broadly speaking, from my point of view at the time, like quite sensible arrangements, there were quite a lot of errors made. There were points missed, be that around impact on benefits or insolvent businesses, points missed, errors made, and approaches that didn't work out in practice how they were originally envisaged. And I guess overall I would look back and say, too optimistic about how well the processes would get rolled out. And that's partly a critique of how they were rolled out, but it is in equal part a critique of the sort of optimism that can often plague us when we begin schemes of any kind. I don't just mean compensation schemes, a sort of confidence that things will be okay, whereas perhaps a more sceptical, pessimistic approach that said, look, this is going to run into an absolute whole load of really specific challenges and it's going to end up being slow and painful. We've got to cut to the chase quicker. That if I could sort of put myself back in my own shoes, I think that is the message that I would want to have given more.
Thank you. Sorry, Mr. Stevens.
No, not at all, sir. Could we please bring up page 23 of the second witness statement? You've got a section there, HSS and the slow beginning, and at 47 you say, I add my own personal apology to the institutional apology that Post Office has already made for slow progress during the early part of the scheme's operation. Post Office and in turn His Majesty's Government had seriously underestimated the scale, complexity and cost of the problem, and consequently His Majesty's Government did not press Post Office hard enough to, and Post Office did not themselves set up a sufficiently robust operation at the start. So I think it's part of what you were referring to there. Could we go, please, to UKGI 30-13178. So just for your note, this document is the note for the meeting in September 2020 that we went to earlier, the briefing note, which
Clear.
sets out matters which would have been discussed at that meeting. Not the minutes, I should say, sorry, the briefing note.
Sorry, Mr. Stevens, can you repeat that?
Of course, this was earlier we went to a meeting in September 2020 and you asked a question about the timing of it.
Can you just give me the reference to that and then I can cross-reference it in my note?
Yes, of course. It is BEIS 40961.
Yeah, fine, I've got it, thanks.
So if we go please to page 10, we see what was then the historical shortfall scheme, update 20th of August, updated version from 25th of August. Closure of the application window. The HSS application window officially closed on 14th of August, and it says that as of 25th August, 2013 claims have been received, amounting to around 100 million, being what's being claimed. So in your statement, you referred to the estimates in July 2020 as being 500 claims costing £35 million. So already there's a significant increase in the scale of the claims facing Post Office by September 2020, yes?
Yes, that looks right.
And it goes on to say, please note that there are a few exceptions to the deadline, notably the cohort of circa 6,200 former postmasters who were identified late by Post Office and notified about the scheme in July. So it must have been clear by September the significance of the claims facing Post Office. Would you agree?
Yes.
And the inquiry will hear evidence that it became clear that the Post Office could not afford to meet the HSS in November 2020. Do you recall that?
I don't remember the exact date, but that sounds perfectly plausible.
And that it then took 4 months to resolve funding within government to meet the HSS.
Yes.
Do you remember that? Do you recall why it took 4 months to resolve the funding issues?
I think this is going to be a not very attractive answer, but 4 months is not particularly slow in the context of resolving funding issues. Sort of in between spending reviews, going back and asking for more money for things is really difficult. So I sort of say that by way of context. The second issue is that at this point, this is effectively the first moment at which HMG says we are fully taking on the financial responsibility that comes with by this point we knew, right, that this was not the only compensation scheme that we were talking about, because the other issues were queuing up behind. So that was quite an important principled decision that was taken during that time. So yes, first of all, it's about getting money signed off and being able to demonstrate why it's the correct number, and going back and forth on, are you sure it's really this number? How much money do you really need? Where are we going to get it from? BEIS, can you find it from your underspends? Do you really need extra money from HMT, etc.? But it's also it's quite a pivotal moment, because it's the moment where, in effect, HMG sort of takes a financial liability that, ultimately by this point was clear was going to be, over £1 billion in aggregate, sort of takes it onto the public purse. Now, by the way, I'm not in any way suggesting that wasn't 100% the right thing to do, but it is a swallow And I think it took a bit of time for the system to make that swallow.
Could we look, please, at page 28 of your second statement?
Perhaps I might just add, apologies, just I was thinking while you were pulling the document up, that it's also true to say that the kind of obligations that the Treasury likes least are open-ended, difficult to quantify ones. So that's why it's a difficult call, because you sort of knew that the number was going to go up. And however important, however worthy the case is, those are not numbers Treasury likes to deal with, because they really make a mess of the kind of bigger picture of the financial forecasts. So it's just worth noting that it's not just, if it just was a one-off bill and you knew exactly the size of it, it's sort of one picture, but a bill that you don't know the size of, that you're going to be committed to over multiple years in an unpredictable manner, that's just particularly challenging from a public finance point of view. Right that government took it on, but I think that would be one of the reasons why it took a bit.
So do we take it from your evidence that it took 4 months because, firstly, it was a big decision, secondly, it was a difficult decision, thirdly, for the Treasury, and thirdly, 4 months in the grand scheme of things for the government isn't a long time for a funding decision?
Yes, I'm not sure I would say it was a difficult decision exactly, because I don't really think there was any sort of meaningful... It's not like there was a cohort of people who were saying, we shouldn't pay this. It was more just like... okay, really getting to grips with it, and sort of, as you always do with these things, kind of hoping that maybe the first number is too big. You know, when people come to you, and this is true in any element of public finance, whether you're the Treasury dealing with the department, or the department dealing with an arm's length body, or a Director General dealing with a directorate, people come to you and they say they want X, and the first thing you sort of do is you go back and you say, are you sure? Is that really the number? Are you sure it's not X minus a bit? Those sorts of negotiations, sort of trying to make the problem be less of a problem from a finance point of view, you'd expect that same kind of approach here. Even though arguably it's completely inappropriate here, I think that muscle is just like so deeply ingrained that will have been going on as well.
If we could look, please, at paragraph 59. Thank you. You refer to an email from Carl Cresswell to you on the 26th of April 2021, update on the compensation next steps. And you highlight, it looks increasingly likely to me that we should consider taking on responsibility for the design and delivery of the compensation scheme within BEIS, though that would have large resource implications. And we see it, sorry, for 58, just to orientate as you're talking about the question of ownership of OHCS. If we then go to paragraph 60, please, over the page. You say, I agreed with Mr. Cresswell that this was an issue. What was your position on whether the government, the department should take ownership of the design and running of the scheme?
I don't think at that point in the chronology of sort of receiving Carl's email, I would necessarily have immediately jumped to a position, but I completely agreed with Carl that we needed to look at it seriously, and it was a really important question, and it was one we were going to have to face into and address. That's what I mean by I agreed with Mr. Cresswell that this was an issue.
If we look at the briefing that followed, please, we've looked at it already. It's BEIS 40990. Have you had a chance to review this briefing recently?
Yes, I've seen this document recently.
And did you contribute to its drafting?
I couldn't tell you. I wouldn't imagine terribly substantially. It wouldn't be usual for me to be involved in the detail of a piece of drafting like this, but I may have commented on it.
We see that it's for the Secretary of State to approve, decide post office ownership of criminal convictions. And if we look, please, at page 3, paragraph 12, which I erroneously tried to go to earlier, says at the end, whether or not to take on direct responsibility is a delicate decision, so we would welcome your views in light of the following analysis. Is it fair to say that in this briefing there wasn't a suggested course offered for the Secretary of State?
That's right.
That can come down, thank you. Was, outside of this written briefing, did you advise the Secretary of State on a position to take at any point in respect of whether the department should take over the running of the scheme?
Not that I recall.
We know that in your documents they refer to the fact that the Secretary of State said that made a decision. Were you involved in the decision-making process in the sense of advising him on that?
Not that I recall, although I couldn't absolutely swear to it. I mean, what I do know is that at the time, perhaps you'd say this is sort of typical, but this was another one which I thought was pretty finely balanced. So I didn't have I wasn't pushing a particular perspective, because I think if I had felt very strongly that one answer was correct, then I would have pushed for the advice to offer ministers a much clearer perspective. But ultimately, I think we all thought that this was quite a difficult call and one that ministers should make.
So from your perspective, the decision to keep it with Post Office was a ministerial decision without significant steer from the civil service?
With advice around sort of the pros and cons, but I don't think we pushed ministers into one option or the other.
Could we look, please, at your statement again, page 31? Second statement, sorry. At the bottom, please, paragraph 64, you refer to the GLO scheme. So even at the beginning of my tenure, it was obvious that the GLO settlement had, while being legally sound, caused a deep natural injustice, as those involved received so little money in their pockets after legal bills were settled and the litigation funders received their slice. And you refer to the scheme being announced. If we go over the page, please. So this was, in the early part, probably due to a conceptual assumption by officials and ministers that the GLO settlement had closed the book on this issue. Obviously, this was legally true. The relevant postmasters had no further legal claim against Post Office, but it was not morally true. But by Carl Creswell's email of May 21, we were clear we needed to act. This proved difficult to make happen. It took significant time to find a legal means to pay the money, which I think you were referring to earlier in your evidence when we were discussing a legal basis for making payments.
Exactly. This is a very hard constraint, in the sense that the department literally just cannot pay out money without a legal basis. It's not a sort of matter for opinion or judgment. We didn't have a legal basis as we understood it. We later found one, and therefore we couldn't make the payment until we had a legal basis. And that's got, just to be clear, legal basis here has nothing to do with the legal claims or anything like that. It's a parliamentary ability to spend. Yes. You can only spend in line with the authority that Parliament has given you.
And at 66, you say this problem was real, and I think BASE and HMT officials did a good job at locating the Appropriation Act option. It does, of course, raise the question why His Majesty's government didn't just legislate to create spending authority, rather, as eventually happened in 2024 under the Post Office Horizon System Compensation Act. I think the answer comes back to my point above about the extent of radicalism both officials and ministers were contemplating. Emergency legislation of this type is exceptionally difficult to make happen and, speaking frankly, requires an enormous head of political steam to have built up. Why do you think a sufficient amount of political steam wasn't there to push through a specific piece of legislation such as this?
I think two reasons. The first is, as indeed turned out to be true, a sense that had we really turned over every stone to make sure a spending power didn't already exist. So it's obviously, in the situation you find yourself where you think, oh, I don't have a spending power, it's obviously much preferable to find that you actually do have one, rather than to run a very unusual piece of legislation designed to create a power, very specifically around something like this on an emergency basis. That's a, it's very much out of the ordinary. That doesn't mean it's not a good thing to do, but people would always turn to what do we have, what do we have, what do we have? And I think there was as there often is when you're searching for something, you think you might find it in the first week, and then you think, oh, I'm going to find it in one more week, and you sort of keep going looking for it. And in the end, we did find it, but it took a while. How could you have shortcut that process? We could have found it faster, but it was pretty obscure. Or we could have just said, stop looking, I'm just going to legislate. But finding parliamentary time is really hard. And so I think all throughout, not that the question particularly came up in that form, but I think ministers would have probably said, like, okay, just before I go to what will be a very difficult parliamentary journey, could you just be really, really confident that you definitely haven't got one?
Was there sufficient consideration of the effect the delays were having on the sub-postmasters who were affected by the absence of compensation payments?
Good question. I think there's probably a bit of sort of boiled frog going on here, in the sense that each little individual bit of delay to look a little bit longer to avoid having to pass legislation probably didn't seem that bad. You always think, oh, it's worth looking just a little bit more, it's worth looking a little bit more, it's worth looking a little bit more. Each marginal extra bit of time makes sense, and all of those little ones are manageable from a postmaster point of view. But when you look at how long the whole thing took in aggregate, you say, how can you have taken so long? You should have done something completely different at the start. But the problem doesn't arrive at you in that form. You constantly think you're about to find something.
So that's probably a good time to take the afternoon break. If we could come back at past.
Yes, certainly. Yeah, fine.
Thank you, sir. Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Thank you. I'll carry on. Please, can we bring up bays 40975? We see this is a letter to Nick Reed from you dated the 29th of September 2021. Paragraph 2, you see it says, it talks about, on account of the management and control of Post Office Limited's litigation costs not being adequate, I am unable to release the payments due to Post Office, due until Post Office can demonstrate satisfactory control. Payments will be made by BASE following a shareholder-approved budget. So what you're referring to here is withholding the network investment and network subsidy payment because the department's position was that Post Office hadn't got control of its litigation costs. Is that fair?
Yes, litigation costs meaning payments to lawyers.
Would you accept this was quite a drastic step to take in terms of the levers that you can pull withholding payments to Post Office?
Yes, and only done after, shall we say, exhausting persuasion as a tool. It is worth saying that, of course, before we did this, we did analyse whether it would actually sort of cause an immediate operational challenge to POL, and we didn't think it would.
Pause you there, because my question is, did you ever consider doing something similar to put pressure on Post Office to increase the efficiency with which it dealt with ski applicants to the various schemes?
No, I don't remember that being proposed.
Why not?
I don't know why people didn't propose it to me.
Why did you not consider it?
Indeed. Sorry, I just thought it was important to clarify. I don't know. Ultimately, probably because we never quite got to the point where there was resistance from Post Office. So I would say on legal costs, by the point of this letter, there'd been a long period of debate around it, and certain people on the government side, in both the Treasury and UKGI, felt really strongly about this point and felt they were just never, ever sort of breaking through and getting the right traction. And Post Office's position at the time was like sort of resistive, as in, we have done all we can, there is no more, we are not doing more. And so there was a kind of sufficiently clear clash to make that feel like an appropriate move. I don't quite remember on pace ever reaching that point where you had a sort of like an ask and a resistance. It was more like ongoing pressure, ongoing movement. It got a bit better, it got a bit better, it got a bit better. And so there was probably never quite the like triggering moment where that sort of like specific intervention felt like the right thing to do. That's my best answer. Although, as I say, it's always hard to say, you know, if something didn't come up, why it didn't come up. But that would be my best interpretation.
Did the department not, was the reason why the department didn't run into the resistance as you've described because it simply didn't push Post Office hard enough on the compensation schemes?
I think it was probably more like, let's say, on HSS during those relatively early days. You know, the scale of the response set up in Post Office wasn't robust enough, as discussed, because they had underestimated the scale of the challenge. But as it became clear, they were moving. It's not like the dynamic was we were saying, get a move on, make this happen, and the Post Office was saying, we don't agree, we don't think it's important, we're not trying. They were saying, yep, we're scaling up the team, we're getting going, we're putting this in place. So there was a sense of responsiveness. It was ongoing. You know, you push a bit more, you get a bit more, you push a bit more, you get a bit more. But I didn't feel that the Post Office was not responsive to asks. They couldn't always enact them because sometimes you can't kind of flick a switch and make something happen overnight. But they weren't kind of rebutting or denying them, if that makes sense.
If we look, please, at base 40967. This is a letter to you from Lisa Harrington, Chair of the Post Office Remuneration Committee, on the 4th of October 2022. And we say, I'm writing to you to apologise for the situation we find ourselves in regarding managing public money and the payment of the CEO's short-term investment plan. And further down, it says that, effectively says that the CEO's STIP payment was paid without shareholder approval. Is that broadly the issue?
Yep.
And that's been raised directly with you to deal with because it's a matter of managing public money.
That's right. So it's come to me as accounting officer.
Could we look, please, at WITN 115-20201? This is a readout of the call you had with Lisa Harrington on this issue. It's the date is, the email sent on the 28th of October 2022. If we go to the bottom, please. It says that SM, that's you, noted that if we looked at this cold without breach, the likelihood is we would have approved. However, noted that it will be tricky navigating ministerial approval. Discusses issues of flight risks, and then suggested next steps at the right at the bottom. It says UKGI based to rework advice for ministers around the retrospective approval will need careful handling. Do we take it from this that your position was that the minister should be guided to retrospectively approve the STIP payment?
Yes, on the basis that it would have been approved in the first place had it been asked about in the proper way by the Post Office, and the fact that a serious mistake was made in governance in not asking for that permission shouldn't ultimately be a reason not to do what we would have done in the normal course of business in terms of approving what is ultimately really a Post Office decision about the STIP.
Did you have any similar meetings with members of the Post Office Board to test Post Office's approach to the compensation schemes?
No, and I'd like to say why this meeting took place, because I think it's important to understand. This wasn't a meeting that took place because I thought, or any of my team thought, that the STIP was ultimately a really important and strategic issue. It's because failure to comply with your duties under managing public money and to do what's described here, that's the right language, as a breach in managing public money, it's a really serious error in compliance. Now, in this case, it's actually not that big an error, right? I mean, in the grand scheme of the things we're talking about, this is in my view, insignificant matter in the big picture. But the fact that an arm's length body commits a breach of managing public money, I can't remember ever seeing it. And I would absolutely expect, just as a matter of course, that would come with a letter of apology and a personal meeting in order to apologise, frankly, to sort of put on record that the seriousness of the fault had been recognised and that systems had been put in place to make sure it didn't happen again. Not in relation to the STIP payment, but in relation to the bigger picture of, back to the sort of regularity issues we were talking about earlier, you just can't have public bodies ignoring or flouting kind of core rules of how public money is administered. So, you know, the fault itself is ultimately a relatively insignificant one in the big picture, but the fact that any fault of this type would take place is a really serious matter, and it's kind of a disciplinary type affair, and so you're bringing in a particular kind of energy, which is you are meeting the accounting officer. This is a kind of a moment of formality, I would say.
You were the Permanent Secretary during a period of time in which this inquiry held compensation hearings, is that right?
Yes.
And you were aware of various criticisms that had been made against the Post Office and the department in the way the schemes were being funded and run?
Yes.
Why was that not of sufficient importance for you as Permanent Secretary to meet with board members to discuss those matters in particular?
Well, I did meet with board members. I met regularly with the chair, so that was a normal part of the course of doing business, and those are exactly the sorts of things I would discuss regularly with Tim Parker, and I met with the CEO as well, so I was engaged in all sorts of different ways.
So my question was a specific meeting such as this set up to discuss compensation schemes in particular?
Because the nature of this meeting was the right person, sort of the offence was an accounting officer offence, if you see what I mean. So I was the channel that this needed to go through. So I was the appropriate escalation point for this kind of issue. There were a whole series of different bits of governance going on around all of the various issues that came up with the inquiry, including the inquiry itself, very regular ministerial contact, regular contact with the board. This was a sort of quite a specific and different channel. I wouldn't have usually felt this was a normal approach to a important issue. I would normally take an important issue to the chair, the CEO, sort of more in the course of an ordinary series of meetings, rather than have a kind of an accounting officer censure moment.
I want to turn to one of those meetings, please, and that's the meeting with Henry Staunton, which is predominantly the focus of your first witness statement. You say in your first statement, we don't need to bring it up, page 6, paragraph 17, in response to the allegation well known to the inquiry, you say, I never told Mr Staunton directly or indirectly, expressly or by implication, that Post Office should stall on compensation or otherwise delay or reduce compensation payments to sub-postmasters. I did not say anything that could sensibly have been understood to convey that implication.
That's completely correct.
Could we look, please, at base 40607? This is your letter to Henry Staunton congratulating him on his appointment. And if we see at paragraphs 2 and 3, you say, each year I write to the chair to set out the key strategic priorities that BASE, as sole shareholder, would like the Post Office to focus on over the coming 12 months. Early this year I wrote to Tim Parker, the outgoing chair, setting out the strategic priorities, and you would say you attached that letter. You're in effect asking him to take over and continue the work that you set for Tim Parker. Is that fair?
Yeah, with a particular focus on the 3 points that I specified below.
And those 3 points that you specified below includes effective financial management and performance, including effective management of legal costs to ensure medium-term viability. And I understand your evidence is that when you say legal costs, you're referring to litigation costs, namely the cost Post Office pays to its lawyers, rather than compensation payments.
Yes, that was very well understood between us and the Post Office at the time.
Could we look, please, at the letter to Mr Parker, which you referred to, which is base 40984. I think it's undated on this copy, but in your statement you say that this was sent on the 23rd of May 2023. If we could go to page 2, please. Sorry.
It can't have been sent in May 2023.
Sorry. Sorry, 2020. It must be 2022. Sorry, that's an error in my...
No probs.
Page 3, please. So this is under the heading on the second page, resolving historical litigation issues. And thank you. If you can go further down, thank you. It says at the bottom, we see, it is right that these issues receive the attention they require to ensure their swift resolution. For financial year 22-23, Paul should, and then there's an indented paragraph. If we could just go down slightly. Thank you. It says the last entry there is challenge Post Office management so their activities are reflective of our shared objectives for compensation, to see postmasters are treated with consistency and they receive swift compensation that is fair for claimants and taxpayers. What do you mean by fair for claimants and taxpayers?
I think this probably goes back to what we talked about earlier about value for money. I think you'll see it in some other letters written to Tim at other times that talk about value for money. And ultimately, this is about saying, we need you to pay full, fair and prompt compensation. but that should be done without wasting money on lawyers, without wasting money through fraud and error, and compensating fairly, generously, fairly, appropriately. But that clearly is different from a process that starts from the premise of, taxpayers have no interest here whatsoever, and it doesn't matter how much you spend.
How do you read generously into that paragraph?
I'm sort of paraphrasing to say that our objectives for compensation were for it to be full, fair, and prompt. It is consistent with that to care about the interests of taxpayers and to want full and fair and prompt compensation to be delivered in a way that protects value for money, i.e. in a way that makes sure that you're not wasting money as you do it, just as any other government goal. If you want to build a power station, build a nuclear power station, let's say, you should do that in a way that is fair for taxpayers, but it should still be safe and it should still be operational. It should still be full and fair.
Mr. Staunton's evidence was that effectively as he took it, a message to say that the government did not want compensation to be overly generous. Would you agree with that?
No.
Why not?
Well, I don't. I am shocked that if that was what he thought, he never raised that with us at any point. So I don't agree that he has that reading, although I understand that is his evidence. And that isn't what we meant in writing it. Because if we were stepping back from the ministerial objective of fulfilling full and fair and prompt compensation, we would have needed to say so. Nobody ever told us to step back from that. Nobody ever indicated we should step back from that. There wasn't any advice provided either to me or to ministers that we were stepping back from that. So that wasn't our intent in writing this, and I don't believe that's how it was read by those receiving it.
So just so I understand your evidence, is your evidence that full, fair and prompt also means generous compensation?
No, I don't think I'm saying that. I'm saying that full, fair and prompt compensation should be delivered in a way that is fair for taxpayers, but that doesn't mean that it should not be full, fair and prompt. Full, fair and prompt is the sort of the first requirement. Within that, like everything else, whatever you're doing in government, you want to do it in a way that is as fair as possible for taxpayers, which essentially means don't waste money while you're doing it.
Can we look, please, at the briefing for your meeting with Henry Staunton?
Before we do, Mr. Stevens, the paragraph that follows that, Miss Munby, and its use of the word balancing, if you read that sentence to yourself.
Yeah, I've looked at that and reflected on it, actually. I'm not sure balancing is a good word to use in this context. And as you can imagine, of course I signed the letter and I totally stand by it, but I didn't draft every line myself. And as I sort of look back on it, I think that sort of balancing isn't really the right way of talking about this, certainly when it comes to fair compensation. I do think balancing has some role when it comes to pace and swift compensation. It gets more complicated in that case because you can go faster at greater expense or not. And that's something that the National Audit Office talk about in their Lessons Learned report. That sort of, when it comes to full and fair, it's quite straightforward to say that isn't a trade-off with value for money or with fairness to taxpayers. I think it's in pace of delivery that you start to see that balance maybe begin to bite. And I think that's probably the use of swift here, I think kind of indicates that's what's running through the mind of the person drafting it.
Yeah, all right. It's those two, the indented last paragraph and that paragraph, which led me to ask questions both of Mr. Staunton and Mr. Cameron about whether they thought that issues like value for money were being taken into account in terms of individual payments, or offers rather, to postmasters. And they both, at least as it seems to me at the moment, thought that that might be happening. Now, you wouldn't know what was happening in the actual administration of the HSS and the overturned convictions process, obviously. But do you think that those words in that letter might have contributed to that sort of thought process?
If they did, I'm sorry, that certainly wasn't the intent in writing the letter. I think it's just maybe useful to note that you're back to managing public money. It says very explicitly that value for money is always a consideration, including in compensation schemes. So from my perspective, when I was reading either this drafting or the drafting in other letters, I wouldn't have felt there was anything particularly unusual or radical in mentioning value for money in the context of a compensation scheme. Indeed, that's what managing public money, which is sort of the Bible when it comes to these things, itself does. So I'm sort of reflecting that overall point of view of government as a whole. I think there is a very big difference between saying, you know, looked at as a whole, you should deliver compensation in a way that is value for money and doesn't waste money. That shouldn't be, but I totally understand what you're saying, Sir Wynne, that it may have been, but that shouldn't be taken to imply that an individual claim should be settled at anything less than full and fair, which was the ministerial intent throughout.
Well, that was my last question, really. Whatever may be said about those couple of sentences in that letter, so far as you were concerned, when you were permanent secretary, did your political masters ever deviate from the policy objective of delivering full, fair and prompt compensation?
No, I think they and we and the Post Office could all be criticised for whether that was always, you know, implemented in full. There's lots of debate to be had about that. But in terms of intent, absolutely not.
Right. All right. Thank you very much.
Just one point arising from that. When you were thinking about, you said full, fair and prompt, you refer to fair, by what standard would you refer an offer to or compensation to determine whether it was fair?
Well, I mean, ultimately, I think that's a question that goes to ministers and what their intent was, just to be clear. It's not for me to sort of be the arbiter of fair. You know, and indeed, I think the schemes, if you look at what HSS says, it sort of goes so far as to say that fair may be greater than the sort of legal obligation, but it doesn't particularly give a exact, precise definition of fair. I think it uses, I'll get the wrong exact expression, but it's something like sort of fair, fully in the round, looking at everything and bringing it all together into a rounded view. You know, fair certainly means at least what you're legally entitled to. That's probably a flaw, as it were, on fair. But I don't think it defines exactly what fair is. You would think that that would be sort of set by kind of the moment of approval of the sort of terms and arrangements of any individual scheme. You know, what did fair mean in that context? You know, fair means something different when you're talking about overturned convictions than when you're talking about shortfalls, for example.
Could we look, please, at base 40631? So this is your briefing for your introductory meeting with Henry Staunton. And if we scroll down, please, we see the agenda. We have first is CEO pay, then NED appointments, finances, recent correspondence, and so on, over the, well, at page 4, please. If we go down, thank you, we see under 4, which was recent correspondence, we have referenced us to the overturned historical convictions and historical shortfall scheme with some briefing on that. Why was CEO pay at this stage at the forefront of your agenda in the briefing rather than the compensation schemes?
Because Mr. Staunton had just written to the department about it.
So it was a reactive, basically.
Yeah, this is an initial meeting with somebody. I haven't had anything from him so far, if you see what I mean. It's a new slate, but the one interaction we have had is a letter from him to the Secretary of State asking about CEO pay, so it would be just normal to respond to that. It's also just perhaps worth saying that that's an agenda prepared for me by the team. You'll note, having seen the readouts from the meeting, that I didn't take the agenda as a gospel of exactly what would be covered in the meeting. I just think it's worth saying that.
Well, okay, well, let's look at the readout then. It's base 40752. Excuse me. So this, if we go to the bottom, please. This is the readout prepared by the department, and we'll come to the first sections in more detail shortly. As I understand your evidence, but tell me if I'm wrong, the discussion on compensation, you say, is further down. If we go down, please.
Not quite, no. Actually, we didn't talk about compensation at any great extent in this meeting.
Okay, that I take that point, and that's your evidence on that. But where it says HS mentions targets ref in inquiry hearing, wasn't looking for an apology, but wider point around being synced up and acknowledging where each other's roles lay, was keen him and Sarah strategically aligned where possible. Was that a discussion about compensation and something that had been said in the inquiry hearings regarding post offices meeting targets?
That's right. That was, I believe, it was either a Bayes or a UKGI lawyer misspoke and suggested that 100% was a target rather than an aspiration, and Poll were upset because it made them look like they hadn't met the target when in fact they had met what was the target, which was 95%. So it was a relatively minor point in the grand scheme of things, but Post Office felt we had, unfairly represented them in front of the inquiry, and that was a fair point. It was a mistake, and we apologised for it.
And just to clarify, is your evidence that that was really the extent of the discussion on compensation?
Yes.
Why did it play such a minor role in your first meeting with the chairman?
Well, I think there's probably two reasons for that. One is, and they sort of go one on each side, right? So first question, why did Mr. Staunton not raise it as a major issue with me? That would be a question for him, but he didn't. So it wasn't like I was responding to any prompting around it.
My question's to you about your
Understood. So why didn't I raise it with him? It's quite specific to the context, actually. So he'd just been recently appointed, and I'd been involved in the appointment process. And I was actually really, at that point, very pleased with this appointment, because Mr. Staunton had real hands-on experience, particularly from his role at WH Smith, in helping turn around performance at a business that, of course, no business is the same as Post Office, but WH Smith has some, quite obvious sort of commonalities with the Post Office. And of the various perspectives that I wanted to get from Mr. Staunton particularly at this point, I was really interested in what would a serious, experienced commercial leader who had sort of done a similar kind of a job before in turning around the performance of a really challenged high street business. I really wanted to understand his take on that. And in my mind at this point, correctly or not, I imagined that Mr. Staunton's personal focus would be in very significant part on the commercial turnaround of the post office, because that was his experience and that was what he was bringing to bear. So he was very new in role. At this point, I could have asked and inquired lots of things about the compensation work, but I think my perception would have been kind of he needed a bit more time on that to really come up the curve, whereas I was, to be honest, hungry for what he was going to say about the commercial performance of the post office, because as you'll see from the briefing documents that run up to this meeting, as well as being concerned about compensation payments, we were acutely concerned about the strategic and financial position of the post office as a business and its viability and future. And I was really worried about that, and I really thought Henry himself, Mr. Staunton, I'm sorry, would have a lot of value to bring to it, and that was the conversation I most wanted to have with him.
So you most want to have a conversation about the commercial issues. We saw it earlier in a letter to the letter to Mr. Parker and the letter to Mr. Staunton that achieving settlements was a key strategic aim for the post office.
Yes.
And did you see as part of your role ensuring that the chair took that strategic objective seriously?
Yes, I didn't use this as a meeting to run through the strategic objectives for the post office. You can see there isn't a sort of, let me recap my letter. That wasn't how the meeting went. I would have assumed that he had sort of taken those points as read. They'd been formally transferred over. This was meant to be more of a... I don't mean off the record in a formal sense, but just a bit more of an informal chance to exchange views about the situation, for him to offer me some perspective and for me to offer him some advice as someone new into role.
If we look at the start of the note, please, it's the bottom of page 1. It says that SM flagged that the relationship on funding with the Treasury is difficult. Their view will always lean towards the begging bowl type scenario, a dynamic worsened by horizon/inquiry costs. What are you referring to by the begging bowl?
There's been a long-standing goal of government, including Treasury, but government as a whole, that Post Office should move to being self-sustaining from a financial point of view, i.e. that it shouldn't be reliant on government subsidy. We can come to discussion about whether that was a realistic or achievable goal, but that was the stated position of government. And in that context, Treasury in particular, throughout this period, long predating this conversation, Treasury in particular had a long record of basically being sceptical of Post Office's claims that it needed government subsidy, and believing that what Post Office should do was focus on improving their own performance, sort of getting their own house in order, strengthening their financial and strategic position so that they wouldn't need government subsidy. And I think a real sense that there was a risk of essentially sort of creating easy money. And if you create a sort of path of easy money for a corporation, you lessen their incentive to improve their own performance. And that perspective, that's what I'm getting at with the sort of begging bowl. They're sort of always asking for more money. That was how Treasury saw Post Office when it came to asks for subsidy. They believed those subsidies should be going to zero, and the Post Office should be weaning themselves off those subsidies. And they were... They were sort of irritated is not quite the right word. I can't bring the right word to mind, but they were sort of frustrated by the constant asks for more and more money. I'm just going to have to stop you there, given the time. I've got that point. The dynamic worsened by horizon inquiry costs. Where it says horizon costs, is that referring there to settlement costs, namely costs associated with the fallout from the horizon issues? I couldn't be 100% sure. It could equally be referring to Horizon replacement costs. It's a bit...
It would be unlikely, wouldn't it? It's for those to be together. It's more likely, would you not think, for Horizon an inquiry cost to refer to, one, the costs of the inquiry that arises from the Horizon issue, and two, the costs associated with compensation that arises from the Horizon issues?
Not necessarily, because Henry had just talked about what the big financial pressures were on the Post Office, and he talked about Horizon replacement, and he talked about rising inquiry costs, and he's talked about telephony. He hadn't mentioned compensation costs because, of course, those came from a different budget and were not really part of this dynamic that we're discussing here.
Mr. Staunton's evidence was that effectively the message was that he could not expect significantly more money to be forthcoming from the government, even if he thought the remediation schemes needed it. Would you agree with that position?
Absolutely not. I do not believe that is a plausible thing you could take away from the conversation we had in any way.
Why are you so confident on that?
Because I don't think that explanation makes any sense given the conversation that we had. The conversation that we had was about my efforts to try to secure more money for the Post Office. So if you go further down in the note, we're discussing how difficult it is, basically this scenario of HMT don't want to give the Post Office more operational subsidy. And I'm talking about why is that difficult? You've got to make trade-offs within budgets, you've got to manage subsidy control legislation, and specifically, HMT at the time had a very clear policy that they wouldn't provide more subsidy to the Post Office in the absence of a long-term strategy, and we didn't have a long-term strategy. So what I was describing was a set of difficulties about securing operational subsidy. I never said anything about difficulties of securing money for paying compensation, and Mr. Staunton himself never mentioned any difficulties with funding for compensation. Indeed, as you rightly point out, the issue of compensation was broadly speaking not discussed, which you can criticise for other reasons, but it is inconceivable that you could have understood me to be saying don't spend money on compensation, when what I was saying, as is recorded in the readouts, is I'm going to try and get you a bit more money to deal with these really big operational and strategic challenges you're facing, but I want you to know it's not that easy to do that because of these kind of practical difficulties of getting money over the wall. None of which apply in the case of, like subsidy control, for example, isn't an issue in the case of the compensation money.
Could we look, please, at Mr. Staunton's note of the meeting? It's base 40918. And if we go towards the bottom, please. It says she also referred to operational issues colouring the Treasury's thinking. Trust in the Post Office Board and management has not been high. They could see this as another begging bowl, so we see the same words used there, request from the Post Office. I said the funding issues revolved around poor decisions made many years ago, Horizon and WRT Horizon, sorry, and related legal issues. Do you accept that that's an accurate note of the conversation that happened?
I think it's just worth saying what we were talking about there by Horizon and related legal issues. Just if you sort of go back to the beginning of the conversation, Mr. Staunton had laid out these three big new difficult cost pressures that the Post Office were dealing with. One, which I think is sort of smaller and less relevant, was the telephony issues. One was the Horizon replacement system, and one was the costs of responding to the inquiry, i.e. the costs of gathering the evidence, working with the lawyers, etc. Those were the 3 points that he laid out at the very beginning of the meeting, and he's playing back 2 of those here towards the end.
So just so I'm clear on your evidence is that what was discussed was, amongst other things, the cost of replacing Horizon. Was that?
Yes.
Yes. The cost associated with the inquiry.
Yes.
But your evidence is compensation itself wasn't discussed.
Yeah, I mean, it might be worth going to the bit in this note where those 3 points are laid out. because it makes it
we
quite
can read the
clear.
note, that's fine, but that's just so we're clear on
Yeah,
your...
absolutely, yes.
Okay, we've got your evidence, thank you. That document can come down, thank you. What are your views on Mr. Staunton's competence as chair while you were permanent secretary?
I had very little interaction. We overlapped by a very short period between his appointment late in 2022 and me moving on to the Department for Science, Innovation and Technology very early in 2023. So I think it would be totally unfair to draw any conclusions about his performance as a chair during that period.
I want to look at a couple of points on what you say about the board effectiveness or improvements of post office governance. We don't need to bring it up, but paragraph 20, page 11 of your second statement, you say, I think post office's internal governance was very much improved, but still not adequate. I think that's by the time you left. Is that right? Can we look, please, at poll 2044646. This is a Post Office Limited Board Effectiveness Report dated the 19th of June 2024. So you wouldn't have seen it in your role as permanent secretary, but have you had a chance to review it in preparation for the inquiry?
Yes, I've seen it after being provided with it by the inquiry.
Can we look, please, at page 8? We've got some key findings there, including lack of clarity on the purpose of the board, with the shareholder relationship inhibiting the board's effectiveness due to perceived interference in Post Office's work and limited visibility around the longer-term funding and objectives of the organisation. Was that a problem of which you were aware as permanent secretary, namely a query over the longer-term funding and objectives of the organisation from the department's perspective?
Absolutely, 100%, yes.
And in your view, had that been resolved by the time you finished as permanent secretary?
No, and if I may, I just expand very briefly on that. We had for some time work running following the settlement at SR 2021, which was actually conditional on carrying out a review of Pol's long-term, or rather HMG's long-term strategy for Pol, which is not quite the same question as Pol's long-term strategy. And we had done quite a bit of work on that, including getting to the point towards the end of 2022, i.e. briefly before that meeting with Mr. Staunton, just to put it in schedule, as it were, of trying to go to right round across government. That's the sort of approval process by which you get cabinet sign-off, right round to launch a more formal review of the long-term requirements of the Post Office by government, and ministers had declined that opportunity and said, no, now is not the right time. So I really recognise this complaint. I was very concerned. I was talking earlier about my level of concern about the sort of financial viability of the Post Office going forward. Of course, that was deeply associated with a lack of clarity about what the Post Office was in the long term, therefore. And at the time, and this is reflected in what I said to Mr. Staunton about the sort of, we need to hobble on, we need to find a way of managing under the strategic steer we already have, because in the short term, ministers were not ready to carry out the kind of full review of Post Office's roles and responsibilities that was really needed in order for government to more clearly define not just the branch footprint, but the services provided, the nature of the financial relationship. All of that needed fundamental refresh, in my view. But it was difficult to get ministers to sign off, I think partly because of, frankly, the political toxicity around the whole issue. and the fact that we knew that any review, sort of regardless of what it ended up concluding about the corporate structure of the Post Office, and I know there have been all sorts of proposals about different kinds of mutualisation and so on, but whatever you did, you faced quite a fundamental challenge that you probably either needed to really seriously increase the level of public subsidy to the Post Office, which had its own challenges politically, or be prepared to say that you needed many fewer post office branches, which is also a really difficult thing to say politically and incredibly difficult for postmasters as well, who were, of course, under enormous challenge during this period. And I think ministers were sort of looking at that really, really difficult choice and saying, now isn't the time, let's get through the inquiry, let's get through the compensation processes, and let's come back to this question in due course. But that did leave a period of really challenging ambiguity for Post Office, and I think that's one of the reasons why ultimately we did end up with, following Spending Review 2021, a series of what you might legitimately describe as sort of short-termist funding interventions, giving over some more money to Post Office to manage the Horizon Replacement Programme, to deal with the rising inquiry costs, etc. You know, sort of dealing with the problems as they arose, rather than fundamentally refreshing the strategy and rebuilding the organisation towards that new strategy.
Thank you. That document can come down. So I don't propose to ask any more questions. I'll see if there's any. Yes. Mr. Henry and Ms. Patrick have asked for 5 minutes each, sir.
Fine. I look forward to their accuracy in estimation. Who's going first?
I'm being forced to go first by Miss Patrick, so I shall go first, sir.
I've never known you to be forced to do anything, Mr. Henry, but there's always a first.
Thank you. Thank you, Ms. Munby. As Accounting Officer, Permanent Secretary until the 6th of February 2023, did you ever cancel an interim payment owed or even due to a sub-postmaster?
Not that I remember.
Did anyone do so on your behalf, cancelling an interim payment agreed with the sub-postmaster?
They may have. I'm not sure what on my behalf means, if you see what I mean. Certainly not at my request.
Certainly not at your request, but obviously under your aegis, because of course you're the permanent secretary, you're the accounting officer. Do I take it from your answers that you were unaware, and I'm not suggesting necessarily that this did occur on your watch, but that you, I'll rephrase it, particularly since I've got very little time. Did you ever become aware of interim payments being subject to a moratorium?
I don't recall that.
Right. You see, we've heard evidence yesterday and today from Mr. Ricaldin that such practices were occurring in your successor department from January this year for some months. And he said, among other things, and I'm going to, the transcript I don't think is on relativity, but I'm going to read out a little bit to you so that you're familiar with it. I omit words, but this is at page 48 of 86, beginning at line 11, page 191 in the internal numbering. In OC, there are many opportunities, as I explained earlier, to pay out more, further interim payments. And what the department was saying to me was, no, we don't want you to do that. That's not the objective anymore. We'd rather you hold on to those and hold out for settlement. I emphasize the word hold out. I was extremely uncomfortable with that, and I think I'm making my point articulating of what is the right thing to do because I didn't want to delay. It seemed to me I was getting an implication to delay redress in order to hold out for full and final settlement, and then I omit words, and this is the facing page, line 7, 192. That was the moral dilemma that I was facing, and they made it clear to me, absolutely crystal clear. No, Simon, the objective, it's there, black and white, full and final settlement. So I then had to issue instructions internally to say those potential interim payments, the government will not approve them now, and they didn't approve them because they were holding out for full and final settlement. Now, that coming from Mr. Ricaldin today and yesterday is an extraordinary state of affairs, you would agree, in your successor department. To cancel agreed interim payments that had been notified but would now not be approved because the department was holding out for a full and final settlement. Notice the absence of the word fair. That would be an extraordinary situation developing from January of this year. You must accept that.
I mean, I haven't heard any of that until just now. So, you know,
So what's your reaction?
My reaction is that doesn't sound right, as you've just put it to me there. The only thing I've heard of that's similar, so I think the only thing I can sort of draw on from my experience, is in the very early days of HSS, I do remember there being discussions about the merits of introducing interim payments or not. And one of the arguments that was made at the time, and probably one of the reasons why we were, in my view, too slow to introduce interim payments in the first place, was about the question of whether kind of efforts to provide interim payments would actually delay making final payments, and that would be bad for postmasters.
Or would it actually, worse than that, expedite settlements at an unrealistically low level because postmasters had been starved of cash? It was as if they were in a famine with the purse strings being tightened against them to force them into precipitate and unrealistically low settlements.
I mean, the language that you just used in describing the evidence just received, it does sound closer to that than to, you know, I'm making a balance of is a smaller payment earlier or a bigger payment a bit later better.
It does, doesn't it? Now, you know how the civil service works. Who would have given the order to cancel interim payments, even those most reprehensibly which had already been agreed?
I don't know.
Now, I must ask you to reflect very carefully on the answer you've given. You know how the civil service work. This is your successor department. I realise that it's not the same department that you were permanent secretary of, but can you help us, please?
I could have come from a few different places.
Such as?
It could have come from one of the oversight bodies. It could have come from one of the officials in the chain, you know, a member of the senior civil service or the director general or the permanent secretary. It could have come from a minister. I suppose in theory it could have come from the Treasury because they were involved in governance. I'm not trying to be unhelpful at all. I don't know much about the case,
So
and I don't know,
host...
therefore, sort of where it might have begun.
Right, I see. Thank you. Nothing further.
Thank you, Mr. Henry. Ms. Patrick.
Thank you, sir, and thank you to Mr. Henry. Ms. Munby, I have very few questions of you, and I know that Mr. Stevens has covered quite a lot of detail about your witness statement and your reflections on when government can and can't take a radical approach to solving problems. And we know your witness statement covers the approach to Ukraine and the approach to COVID, for example. I'm not going to go back over that. And I know you've said you can't really comment on things that happened after you left your post as permanent secretary, and you don't want to comment necessarily on how the change of approach came about. But I'd like to look at a couple of your observations in your second witness statement, if that's okay. If we can look, and you don't have to turn it up, I'll read it for you, and you can trust me that I'm reading it from the page.
I know my witness statement reasonably well.
Indeed. So. At paragraph 72, you say, Of course, in the round, looking back at events, an initial underestimation of the scale and depth of the challenge in truly delivering redress was then followed up by a plausible and incremental set of decisions on how to deliver full and fair compensation, with those decisions focused on deliverability, fairness, appropriate use of public money and good governance, justifying and building up the response piece by piece. And just stopping there, you said something a little bit like the boiling frog scenario.
Yep.
Yeah. Such considerations are the mainstay of government, and we should not leave them behind hastily. However, we had begun down the path with a deeper and more complete, understanding at the start of the true human impact of all that had happened previously, I wonder whether both officials and ministers might have taken bolder, more radical decisions earlier that would have allowed us to reach towards full and fair redress faster and with less distress for postmasters. And I just want to ask you, did ministers, looking back with your reflection, see this scandal, this scenario, as a business as usual project that could be approached with business as usual solutions, always falling back to the usual principles of government and public restraint at the initial stages?
Broadly, yes, but business as usual is a very, very broad tent in government and includes doing absolutely extraordinary things that are very unusual. So I don't mean that they thought it was ordinary or straightforward or very much like everything else we were doing, but the distinction I was seeking to draw in my witness statement was I have seen a few, very few, but non-zero number of things in my roughly 5 years in the civil service where ministers have very explicitly said, you know, from almost day one, I want you to put precedent completely aside. I am not interested in any of your useful, practical points about governance or managing public money. Just do it. Make it happen, and have sort of like broken the frame. And the two examples, I know you said them and I don't want to waste time, but the two examples where I've seen that were at the very beginning of the COVID crisis as it related to the survival of small businesses, and secondly, after Russia's invasion of Ukraine, as it related to preventing the very precipitate rise in energy bills for households and businesses across the country. Those are, when I say business as usual, I mean not that, rather than sort of saying it was seen as a sort of in a box with a load of things in the kitchen sink to be dealt with in a very ordinary way.
Indeed. And what we can see from, and I think taking from your evidence, is that it was only when ministers were forced by the political pressure to face up to the realities of this scandal and its impact on the individuals concerned, the sub-postmasters themselves and their families, and the impact that that was having on public consciousness. Then it was seen that this was an issue which needed a truly radical solution, which stepped beyond those, and I'm calling them business as usual prospects, and the underlying principles behind them.
Yes, I think that's a fair summary of my evidence.
And can we look just at one other section of your evidence? I just want to look at a part of your evidence on the briefing that was being provided to you. And at the very earliest part of your second witness statement, you say, with hindsight, you have two reflections. First, that the briefings were, perhaps unsurprisingly, typical civil service briefings, focused on the facts and next steps. I couldn't honestly say that they brought home the ongoing human tragedies at the heart of this case. And with hindsight, I think I should have personally pushed to meet with the postmasters myself. Second, I'm not sure that these emphasise sufficiently the ongoing cultural challenge at the post office. Now, that's reflecting on the briefing provided to you. Do you think there was a similar failing in the briefing that was being provided to ministers?
I think that sort of probably goes almost necessarily because there's a great deal of overlap in the briefings. I suspect, though, ministers, more conventionally as part of their role, will have been meeting postmasters at various points in this process, and of course, officials within the department and very extensively in the Post Office. I'm sure Simon Ricalden talked about the work that he did on that front. But I think the straight answer to your question is yes. I think that same criticism is likely to be true, indeed is true, of the briefings that were provided to ministers.
And no matter what sub-postmasters and those that were representing them and others may have been saying about this being the biggest miscarriage of justice in modern history, and about the impact on individuals who'd lived for decades, some of them, with the stigma and the harm that had resulted from the events of their prosecution. That ministers themselves at the outset may not have appreciated that this was a truly unique set of circumstances that really needed a radical solution.
I think it is difficult to calibrate when something moves into that radical space. I'm trying to think of sort of sensible analogies, but very terrible, challenging things happen an awful lot in government. Dealing with, widespread rioting across the country, or dealing with a shortage of prison places. Just to take some examples, say from the last 6 months or so. So the scale of what we're talking about in terms of kind of outrage, perception really has to be very, very, very high indeed. And I think it is true what you say, but I also just really want to emphasise that that doesn't mean that ministers didn't understand that this was a terrible, horrific injustice, or think that it was a really important priority to fix. And even within what I've described as a kind of incrementalist approach, and I appreciate that many would criticise it, but nevertheless it did involve committing well over £1 billion of public money, even within that frame, and that was a insufficient but serious response.
Thank you for your response. I was simply reflecting on your own evidence that there was a shift in perception.
Yes.
Thank you. I don't have any further questions.
Is that it, Mr. Stevens?
Yes, so that's it.
Well, thank you very much, Mrs. Munby, for making 2 witness statements and for coming to the inquiry to give evidence. Well, it's all been this afternoon, though I dare say you may have been here during part of the morning. Anyway, thank you very much. I'm very grateful for you, very grateful to you for helping the inquiry in the way that you have.
Thank you.
So we'll resume again at 10 o'clock tomorrow, Mr. Stevens?
So I think it's 9:30.
9:30, I'm so sorry, you're quite right. Yeah, 9:30 tomorrow morning.
Thank you, sir.